Hello, my name is Aaron Somberger and today I'll be presenting on the case study of Complete Surface Finishing Proprietary Limited, which was a liquidation I was involved in 2017. In particular, I will be focusing on the legal, commercial and practical issues that arose when determining an appropriate method to realise the company's assets and business.
The liquidator was first contacted by the company's accountant, who requested that he meet with the director of the company to discuss the options available after it had received multiple payment demands from the Australian Taxation Office. In the same meeting, the director advised that the company was operating a mechanical engineering business that focused primarily on preparing specialised robots to assist organisations in the manufacturing industry. The director advised that the company's main reason for failure and not being able to pay its debts was due to the liquidation of its main debtor, who owed the company in excess of $500,000. At the conclusion of the meeting, the liquidator and director agreed that the company was insolvent and recommended that the members put the company into a creditor's voluntary liquidation. The company was subsequently placed into liquidation approximately 1 month later on 30 June 2017. During the month between the meeting with the directors of the company and the appointment of the liquidator, 7 of the 9 engineers employed by the company tendered their resignation and joined a competitor in the industry.
Day one of our appointment, we entered the company's premises to inspect the assets and held a meeting with the company's director and CFO to gain a further understanding of the work that was going to be required in the liquidation. We identified that there were 4 main issues that needed to be further investigated before we could develop an appropriate realisation strategy for the company's assets. These being 1. Obtaining a valuation of the company's assets, which we arranged on that day. 2. Understanding the company's debtor contracts on foot. 3. Dealing with the company's secured creditor who had an interest in the company's 6 robots. 4. Ensuring that we had the continued access to the company's premises. These issues are discussed in detail in the following slides.
As discussed, on day 1 we engaged an independent auctioneer to conduct a valuation of the company's equipment that was located at its premises, which consisted of fixtures and fittings, tools of trade and robotic equipment. And in addition, we requested that the auctioneer provide a recommended realisation strategy for the equipment. Within a week of our appointment, we received the valuation report from the auctioneer that estimated that the company's unencumbered plant and equipment had a market value of approximately $60,000 and an auction value of approximately $40,000. However, given the quantum of equipment that made up the total value, the auctioneer estimated that the selling costs, including removal costs and commission, would be approximately $20,000 if the equipment was sold at auction. By understanding the estimated net proceeds from the sale of the equipment if it went to auction, the liquidator had a better understanding of what he could accept as fair value for the equipment if a private offer was received or the landlord requested that we vacate the premises and the equipment needed to be immediately removed. After our meeting with the director and CFO and our initial review of the company's records, we identified that the company had 4 contracts with clients currently on foot. The breakup of the contracts was 3 contracts that were in the research and development stage with minimal, if any, work completed to date, and 1 contract with a total value of $200,000 that was approximately 50% complete, with full payment due upon the completion of the contract. After conducting a risk assessment to determine whether the liquidator would be able to complete the project himself, the liquidator decided that his personal exposure was too high to trade on the business and he would not incur any expenses to complete the project as he was currently unfunded in the liquidation. Accordingly, we determined that the only way of realising any value from the contracts would be through selling the ongoing contracts to another party. After discussions with the CFO of the company, he provided us with an indication that he would definitely be interested in purchasing the company's contracts. However, upon a detailed review of the contract between the company and the main debtor, we identified that the contract was subject to an ipso facto clause and the client could terminate the contract upon the insolvency of the company. In order to save the value of the contract, we arranged for an immediate meeting between the liquidator, the debtor and the company's CFO to discuss the insolvency of the company and the completion of the contract. The debtor indicated that they were still very keen to have the contract completed, and after protracted negotiations, the debtor agreed that we could sell the contract to another party subject to his approval, as long as we can get it sold in a reasonable amount of time and his work would be completed by the due date. This gave us a starting point to start negotiating with the CFO regarding the purchase of the company's debtor accounts. Given the other 3 contracts were still in the research and development phase and no progress had been made, no further action was taken in relation to the debtor contracts at that stage. As discussed earlier, the company owned 6 robots which were subject to a security interest in favour of a large robotic supplier. Shortly after the liquidator's appointment, he requested that the secured creditor provide details of their security interest, including a copy of the agreement that granted their security interest, details of the amount owing to them, and invoices for each respective robot that was supplied to the company. Shortly after issuing the secured creditor with a letter, they replied providing a copy of the master supply agreement dated 30 June 2016 and invoices for each respective robot ranging from 1 July 2016 to 31 July 2016. The records available to the liquidator indicated that all robots were delivered on the day that the invoices were issued. The liquidator's search of the personal property security register confirmed that the supplier and secured creditor registered their security interest on 13 June 2017, which was 17 days prior to the liquidator's appointment. Based on the information available to the liquidator, his initial view was that the security interest would vest with the company pursuant to Section 588FL of the Corporations Act, as the secured creditor failed to perfect their security interest before the critical date, and in this case would have been the 6 months prior to the liquidator's appointment being 1 January 2017. Given the value of the assets subject to the security interest was approximately $80,000, and in order to protect himself, the liquidator engaged a solicitor to confirm his position. The solicitor confirmed the liquidator's position and then wrote to the secured creditor, putting them on notice of the liquidator's position and his intention of dealing with the assets. After protracted negotiations between the liquidator's solicitor and the solicitor acting for the secured creditor, the secured creditor conceded that they failed to perfect their interest in the required time, and the secured assets would vest with the company, and the liquidator was free to realise them for the benefit of creditors without having to seek directions from the court. Whilst we're developing a strategy to realise the company's assets, we require the continued access of the company's premises to 1, store the company's assets, and 2, allow us to walk potential purchasers through to inspect the company's assets. A serious issue arose when the landlord issued us with a notice to vacate the company's premises after becoming aware of the liquidator's appointment. We immediately got on the phone and contacted the landlord to advise that we required the continued access to the premises for at least another 3 weeks while we assessed our options. In order to appease the landlord, we entered into an agreement with him where the liquidator made a small goodwill payment and provided written confirmation that he would pay rent for the period he was in control of the premises. In addition, the landlord had a condition that the liquidator would make the premises available at any time so he could walk potential tenants through the premises during the period. By accepting this agreement, the liquidator gave himself more time to consider all of his options with respect to the realisation of the company's assets. Now that the liquidator had dealt with the 4 main issues previously discussed in this presentation, he had a full understanding of the assets available to him to sell as liquidator of the company. Accordingly, he commenced a 1-week sale campaign to allow interested parties to submit an offer to purchase the company's assets, which included the unencumbered plant and equipment, robots that were formerly subject to security interest, and the ongoing debtor contracts. Whilst the liquidator would have liked to have had a longer sale campaign, his hands were tied as he could not guarantee that the debtors wouldn't terminate the company's contracts and or the landlord commencing action to have the liquidator vacate the premises. Once the sale campaign had completed and he had finished his negotiations with multiple interested parties, the liquidator accepted an offer from the company's former CFO in the amount of $200,000 to purchase the company's assets on an as-is, where-is basis. This proved to be a great result for the creditors of the company as it saw a distribution of over $100,000.